Yep. And that would be the other thing too, I think, is in some of these things with FMLA, one of the things that you can do, I think, to help the people you work with and help yourselves even, is be proactive sometimes. So that in the case where you know that you're going to have 2 or 3 appointments and you think it's going to qualify for FMLA, ask for the paperwork, because that's a great point. If you're going to the doctor, it's better to have the paperwork there than trying to follow up with it after the fact. And so sometimes it might be good to be proactive. The law says 7 days is coming to mind, is what a court, I think, has determined is reasonable. But I think the law just says that they have a reasonable amount of time to get you the paperwork. So in the way that you described it, I don't think they've done anything wrong. They've made it harder on you because they're slow, but I don't think that they've technically violated the law.
Let me ask you this, is there a reasonable amount of time that I have and I have to get back?
Yeah, and I believe that the paperwork is going to say that this should be returned by such and such a date, but even if there's mistakes, I think that they've given as much as 30 days. But again, you want to make sure that if you know it's going to take you long, and the number one thing here is, and actually, you know, communicate with human resources, let them know what you're doing. A lot of times if you don't, or you aren't talking to someone, and I know big companies, there's probably 47 people there and they, you know, don't always talk to each other either, but you want to make sure that if you, it's...
The problem, we call our supervisors normally.
And that...
They're supposed to go in there, but it's in all laws, it's saying supervisors are supposed to be involved in private information.
And that's, and Family Medical Leave Act stuff is not supposed to, and one of the things on the outline is how this interacts with some of the other laws. And the Americans with Disabilities Act specifically has a privacy requirement in it. Family Medical Leave Act doesn't have the same sort of privacy. However, if you qualify for this, you probably qualify for that. So they have to follow both at the same time. Well, there's actually a HIPAA, and this is one of the things that that I have on to talk about at the very end, and it kind of wraps everything up. But there's actually a portion of this where it specifically references a waiver to HIPAA that you can provide to your employer. You don't have to, okay? They aren't going to force you to waive those rights, but it falls under that, going back to where we were, where you have the duty to tell them the information necessary for them to determine whether or not you have a serious medical condition. And so if you refuse to waive your HIPAA rights, the instance where this comes up is they can say, we'd like to talk to your doctor. And you're like, no, I don't. I mean, I'll go back to myself, where I was arguing with the people in the Human Resource Department. I didn't want them talking to my doctor. I didn't even want them to know the reason I was going on it. Well, this regulation says that you can waive your rights to HIPAA for them to talk to your doctor. And that's okay, but they can't force you to do it. But if you don't do it, and they don't have enough medical information to certify you, then you get kicked out of the FMLA protections. So it's...
You have to watch how you tread on this water, because if you're giving the company a piece of paper saying waiving your HIPAA rights, it's got to state in there somewhere for this incident.
And it will. It's a specific regulation under the Family Medical Leave Act, and it will specify that they're only able to talk to them about this condition. Generally, how that's going to happen is on this form it says, give us information about the condition, and if the doctor just writes, you know, stomach ache, well, some stomach aches might qualify, some stomach aches might not qualify, so they want to ask the doctor what he meant by that. That's going to be what they want to do. The thing is that they also can ask for a second opinion. So there's avenues for them to take, and a lot of companies would rather not talk to your doctor because it opens up a bunch of problems that they don't want to deal with. But they have that right.
Right. Doesn't that play into the? Isn't there a 12-week for rolling or 12-month period? You have protection under FMLA.
Yeah.
Then, but the company has a tendency to. You go off more than 3 days, you're going to get put on it. Because we all know we're going to be qualified. They put you on that so they can eat up that 12 weeks. So if you're a habitual absenteeism employee, then they say, oh, okay, you're not protected after 12 weeks. Now we can start paying you. absence or promotions or anything else. That's why they put us on it.
Oh, no, absolutely, absolutely, and the whole, I mean, all the litigation involved with FMLA is people who got fired after they came back. And you're absolutely right. They want to count those days against you so that if you need to take time later, it's a less of an amount of time that you can take. And again, you have to qualify though for those absences to fall under there. If you have the flu for 3 days, I'm going to argue you don't qualify for Family Medical Leave Act, even though you've only had 3 days off. So
How do I determine? I'm going to be sick all week. I'm going to be gone. I went home with the flu. I come back in and say, oh, I got the flu. I'm going to make a doctor's appointment, but it's not for another 3 days. So now we're in 5 days, 6 days. We're in the following week. You're automatically going to be put on the FMLA. Start eating up that.
Flu isn't covered.
Yeah. Well, and okay.
But absence is what we're running.
Yes. Okay, we got a couple of things working here. One is that, yes, all sorts of medical conditions may or may not apply. And I understand completely what you're saying. I'm going to take some time off and they're going to put me into FMLA. You got to be careful. They can't put you into FMLA. You have to qualify for FMLA. However, if you fail to turn in the paperwork that says, if they say you've missed enough days, we think you might qualify, here's the paperwork. If you don't fill it out, they're going to be in a tough position, and I would imagine the court's going to be able to later say, they gave you the paperwork, you didn't get it filled out, they can count those days against you. If you go to your doctor and say, hey, do I qualify for this? The doctor's going to know. Doctors probably are sick of filling out FMLA paperwork by now. They're going to say either you qualify for it or you don't. If you know I'm making an appointment 3 days in advance, and I'm going to be off more than 3 days, call and say, hey, I need FMLA paperwork, ask your doctor, maybe he's got it, go on the website, print it off, give it to your doctor so you can take it in if you don't want to count it against you. But yes, absolutely, and because this gives you 12 weeks in a rolling calendar to miss work without being able to be fired. And I imagine that you don't have that many weeks of, absenteeism is going to add up points or whatever otherwise. So that is part of what the company is.
I've represented workers before that have been. They waited until after the 12 weeks. That's what they ran. They don't care. They're throwing money to heat up that 12 weeks. It's our benefit and their benefit.
Yes. Both sides, there is, in a lot of ways, both sides are giving and giving a little bit. And that's, see, the one thing that they want to use it so that you can't have additional absences, because the big thing is they have to return you to your same job. They can't terminate you. They can't do all of these other things based on it. I'm sorry, in the back, you had a question.
Now, when we have to go get those forms, now let's say you're sick and you go in, the doctor takes you out for a week, company sends you the forms, and let's say the doctor charges you. Can we like print these forms out before we go and not wait for the company? Or is there any recourse we can get for having to get these forms filled out and having to go back?
The first doctor to have your initial doctor fill out the forms is not going to be something that the employer is going to probably pay for. Can you print the forms out beforehand? Can you talk to whoever and get them beforehand? Absolutely. The law does specifically say that if the employer wants a second opinion, they have to pay for that, and they have to pay for the third opinion.
A second opinion from the same doctor or a different doctor?
Different doctor. So if your doctor is going to put
What
you...
about filling out a different form for the same thing? By the same doctor?
Let me make sure I understand. You're saying if you go to the doctor tomorrow and then you still miss a couple of days and your employer sends you paperwork the following week and says, we want you to have your doctor fill these out, and your doctor says, I'm going to charge you X amount to fill out this paperwork, can you make your employer pay for it?
Yes.
No.
What about if they get the paperwork back and they say, your doctor didn't fill it out right, you have to go back? Or, any kind of way they're requiring you to go back because they don't like how the paperwork's filled out.
Okay. Let me go back to the first question. Under the Family Medical Leave Act, they aren't going to pay for the first one. That is potentially something I imagine that would be bargainable, though. However, two, it might actually speed up them processing the paperwork too, but that's neither here nor there right now. The second thing you asked, though, is whether or not if they don't like what the doctor says or how he says it, will they pay for that? The answer is probably not, but the thing you have to remember is that if they don't like what your doctor says, they have to have, I mean, it has to legitimately be deficient, okay? If your doctor fills in this and answers the questions and gives them a sufficient amount of information, for example, let's say that,
Well, to give you an example,
let's say,
I had an employee who's had an FMLA paperwork returned back because the doctor changed the date, crossed it off, and wrote a new one, but didn't initial the change. They had to go back in and get a new form.
I don't think that they should have had to have filled out a new form based on that, okay? But again, you're in some ways playing with fire. If they can ever argue that they don't have enough information to certify you. The story you just told me about crossing something off, that doesn't seem to meet that standard where they couldn't certify it based on that.
It's pretty normal for our company. If there's anything changed, no initials,
Well, they think the employee didn't.
they think the employee did there, you have to go get a new form filled out.
Yeah, hang on one second. The problem is, for me to stand here and tell you on any different situation that occurs, it's nearly impossible. And the biggest problem is that you really need to be careful, because of what you're saying, I don't think is even near what the law requires. But if it's the return to work date and they have a legitimate reason to, maybe the employee's gotten in trouble before for being dishonest, so they can say they had a reasonable suspicion or something like that. You see, all of the facts are going to play into how they're able to handle it and what the court determines to be reasonable. But in reality, as long as the doctor has provided enough information for them to figure out you had a serious medical condition, it should be sufficient. Oh, right, but hang on one second first. Yeah, go ahead.
Okay, I have two questions. One, if you're off for, let's say, 5 or 6 weeks, how many forms are you required to keep giving them? And the second question is, once you run out of FMLA, do they legally have to require some kind of a notice to you that you no longer have any FMLA?
First question is, it depends. which is like my favorite lawyer answer, or maybe, but you said how many forms can they legally have you fill out? It depends, because it depends on how many. If it's the exact same serious medical condition, the answer is 1 per 30 days. Now, if they think that it could be a second serious medical condition or a different exigent circumstances or a different reason under FMLA, then they could have you refill all the paperwork. Question number 2 was, I forgot. Do they have to notify you that your time is up? Not necessarily in writing. If you call and ask them and you make a request and they mislead you, then they're going to have trouble justifying anything. But no, did they technically have to notify you? No. There's no requirement that they keep you updated on how many days you have left.
So if you've exhausted your line and you just know it, and then you call to get FMLA form, they send you the form, you go to your doctor, pay them to fill out something, then they can go, but you don't have to be social media.
They usually doesn't have to, usually file, because you're right, when you do that, you can call if you want to come, tell them you're not eligible. Thanks, Tim.
Well,
Thanks, Tim.
and I can't say, yeah. The problem is, and this is essentially the, I brought along, I just found this the other day, and I brought it along as a wrap up to show you exactly what not to do, really. And my advice to you in those situations is, if they're not violating your union contract and they're just asking you to fill out paperwork, you're generally in a better position if you do what they ask. rather than not, just because, even if it seems unreasonable at the time. There was a case that just got published or a couple of days ago from a different part of the country, where this employee had a disagreement with his supervisor, sent some emails out, and then took FMLA leave. While he was on FMLA leave, he sent out some more emails, and he had a meeting where he asked his supervisor if they would fire him, and they said no. And he said, well, if I quit, am I ineligible for unemployment? They said yes. And he goes, okay, well, I'm not quitting that. And he went and took more FMLA leave. And while he was on the second FMLA leave, the internal security was looking at the emails he had sent and decided he might be somewhat of a threat to the other employees, so they deactivated his badge. He went to return to work at the end of his FMLA and his badge didn't work, so he got in his car and went home. He said, I tried to go to work and they wouldn't let me in the building. He didn't ask anybody, he didn't talk to anybody on the site, he just went back home. His supervisor called him twice on the phone and left a voicemail asking him to call back. He didn't call back. And he later, they sent him a letter 2 weeks later saying you missed, your FMLA was up on this date, you missed 3 days after that, and we've terminated your employment. He filed suit saying that they discriminated against him or interfered with his FMLA rights. And the court said, while the process of terminating him wasn't exactly smooth, you as an employee have a duty to at least be, to inquire about things. So by showing up at work and your badge not working at the door and then deciding that that by itself is enough that you can just go home, they must have fired you. His testimony was, I thought they fired me. And the court said it's not enough. You can't have a wrongful assumption. So you do have a duty to inquire a little bit. Question back there, and then there's one in the other court. Go ahead.
Now, can a company based on FMLA law make unionized and non-unionized benefits different under FMLA? For example,
The easy answer to that is yes. If your union contract calls for better, if the union contract calls for better benefits than FMLA provides, then the union workers can have those better benefits that non-unionized workers wouldn't get. And I mean that in, let's say that you have, the union contract provides for additional sick time or provides for your benefits to be paid while you're on unpaid leave. Because FMLA says they can't get rid of your benefits per se, but they can require you to pay for your entire benefits while you're on FMLA. So if the union contract says that they'll pay for those benefits while you're on FMLA, you get that, a non-unionized employee wouldn't get that.
for example, I know what you do,
Go ahead.
but pregnancy, unionized person can only take 6 weeks. Non-union can take 12 under FMLA.
Without looking at other facts or circumstances, I would say that I would have a problem with that. Because Family Medical Leave Act says 12 weeks. So they're actually providing less of a benefit than is available under federal law. That would be my interpretation.
If you're off with a surgery at the beginning of the year and your insurance covers your days off, you got enough time to cover your surgery, the company automatically puts you on FMLA leave. You use up your 12 weeks, even though you've got that coverage by your contract. At the end of the year, your parent develops cancer or something, you need that time off without pay, they don't have to give it to you, correct?
Correct.
Now, why can they coincide that FMLA right along with, if I've got a contract that says I got 12 weeks off with pay, why do they do both? Why, it's like double dipping.
Yeah, it is, and it's allowable under the law, and it actually specifically says that. Let me give you sort of the only way to work around that would be that if you provided in your union contract that FMLA didn't start until after other benefits ran, then it would be allowable. But I have never seen that in a contract. I'll give you an example. Though sometimes they want to change language in your contract. Before FMLA, a lot of contracts called for leave of absences that might have been more than 12 weeks, even though they were unpaid, but you wouldn't get fired. And so a lot of people in negotiations would go in and they'd say, well, this is the new law, we need to change the language. And you actually are giving it up. If your contract says, for example, when I was a teacher, the contract said you could have up to a year unpaid leave without losing your job. You didn't get paid, you didn't receive any benefits, but you wouldn't get fired. That is a benefit above and beyond FMLA. You see, so that they can still count it against my FMLA days, but the contract gives me an additional benefit.
What about with comp? What if you're on comp? Can they run FMLA coincide with workman's comp?
Yes. Yes. The answer, I believe, is yes. And if for no other reason than to try to come back onto what I was talking about, FMLA, ADA, and workers' comp converge in a lot of areas. And you just brought up one good example. Someone earlier asked about keeping medical information private. And so the thing is that sometimes you aren't talking about just one right that you might have, you're actually talking about different rights. Now, workers' comp and Americans with Disabilities Act are, at least at the basis, a way of allowing you to stay at work or to come back to work. FMLA is actually the opposite. It's saying you get to stay home. So where they intersect is often tenuous and fraught with having to look at two things. But my answer to your question would be that, yeah, they can run them concurrently. We've talked, and okay, go ahead.
Earlier you said that they have to fill up, they ask you to fill out your documentation every 30 days.
Yes.
Is that even if you have a chronic condition?
If you have a chronic condition, and one thing that we haven't even talked about at all is intermittent leave. And that would be leave that's not taken all at one time, but it's taken over the course of the 12 months. Generally, they can ask you to recertify that you have the medical condition every year. So if it's a chronic condition, yes, you could be asked to fill out that paperwork on a yearly running cycle. And I would assume that they would make you do that as well.
But if you have it filled out and have an FMLA situation, they can't make you like 6 months later fill it out again.
No, not if it's the same. I mean, if it's the same condition and your doctor has said that this, because usually for intermittent leave, they're going to check on there that there's a probable ending date. So let me give you an example. Let's say that your doctor says you have a chronic condition, but that chronic condition is likely going to only exist in a qualifying nature for the next 6 months. Then in 6 months, they ask you to fill out the forms again. That's fine. If your doctor says there's no sure end date,
If it's chronic, like asthma, like severe
yeah.
asthma.
So the doctor writes in the box for end date, he writes forever. Are they going to make you fill that out every year? Yeah, because the regulations say they can. But if they ask you in 6 months, I don't think they have the right to do it. Now, here's the situation is, someone's going to ask me, well, that's what they're doing all the time. What should I do? My advice would be to email the paperwork over to your doctor and ask them to fill it out again. Or talk to your union steward and file a grievance about it. Because the problem is being stubborn. Like my story from the beginning about me as a stubborn employee, it ends up getting you into trouble if you want to rely on these rights later on down the line. The judge or whoever's making the decision 5 years in the future is going to have the benefit of hindsight. They're going to say, well, you were just a stubborn pain in the rear, and we're not going to cover you because of that. Yeah. You guys, that table should have sat in front of me.
That's Grand Rapids, and it's all messed up.
In our contract, it says that the employee has a right to use like a paid personal absence or anything like that for FMLA. Right now, if we have like our parent gets sick, they make us use our vacation time for that.
Not sick time?
Well, not per parent. Because the contract says may, it doesn't say that we have to, it says the employee may.
Okay, my answer to that is that according to Family Medical Leave Act, it says your contract controls. Because they can require, under Family Medical Leave Act, the employer, if let's say you were non-union, the employer can require you to use all sick and vacation time first. It's possible. So my thing to you is your contract controls that. So if your contract says may, it sounds like it's a grievance.
So if somebody does want to use it, we should file a grievance based on our contract.
That, based on what you've told me your contract says, yes. Okay. You mean the doctors aren't really being very helpful? Yeah. No, I completely understand that, and that's, you know, if your employer was timely with the paperwork, so you were taking it with you when you went, and this is maybe a thing about being proactive is, I imagine if you're sitting there with the doctor and watching them fill it out, you're going to get it quicker, because I completely understand what you're saying. And my answer is there's nothing in the law that's requiring the doctor to comply. The thing to tell your fellow coworkers is, you know, make the point to your doctor that if they don't fill this out in a timely fashion, I'm going to get fired. No, that's and the thing is that likely whoever is saying you have to get the correction fixed knows that it's going to upset the doctor, and so they're doing it on purpose. You know, everybody's trying to needle everyone. We've been talking a lot about these forms, and there was actually I'd like to let's see. Yeah, the law. If I understand your question, you said is family care the same as Family Medical Leave Act? Before it was FMLA, I believe that its name was family care, and it only applied to taking care of someone else, not your injury, and it was or illness, and it was shorter. So I hope that answers that question. I want to go back to what we've been talking about with the certification. There. It was in 2011 in Ohio. The judge said that the doctor's certification of a serious health condition is sufficient if it states the date on which the condition began, the probable duration, the appropriate medical facts, and the statement that the employee is unable to perform his job duties. And I imagine that, again, while what you've said about changes and slashes, the problem is likely to be caused if it's the end date of the FMLA. I would imagine that would be. Now, if they're just upset about other things, I can't answer that, but I would imagine that's the key. Okay, one of the, I think I'm way over my time, but there's a couple of things that I'd like to.
I didn't think you were going to get hammered this afternoon.
I should have been doing some reading while I was sitting on 75 there, not going anywhere. But,
I like his answers maybe, because when I've been doing these, you never, on one of these, you don't get asked a question, you don't know the answer. And I really think sometimes the speakers learn more from these than the audience, because the questions are questions which come up in your everyday use of these. And we're more on the academic and legal end of it, you're on the battle line. So these are questions which I've learned a lot here today, which I didn't know about. There's a lot of questions I'm not sure there are clear answers.
and actually, I think it's much more helpful if you ask the question, because even when I made my outline, I left it kind of with room to maneuver, because I knew that what you're dealing with is different than what I think or what I read. Question way back in the back.
The spirit of the law that when they did this was had no intention of the companies using it against the employees the way they are. Was it? What was the spirit of the law? I mean, wasn't it originally brought up to aid employees that didn't have a lot of good sick benefits, didn't have a lot of this or that, and maybe weren't necessarily organized? And companies are using it and twisting it around and have totally, excuse the term, but bastardized the whole process to benefit themselves. And penalizing employees that have a right to take their sick time within the letter of their company, and then have a federal law that says, now I'm out of sick time and I broke my leg and I'm off for 6 weeks. But I can't because they wasted it.
Yeah, and you're absolutely right. The spirit of the law, I think, was originally to protect people who got sick from losing their jobs. And I think it was intended for non-union employees. I think that, you know, back in 1996, I think that there were, again, my teaching contract when I taught had better than FMLA at that time. You know, there was already protections built in there. It was for people who didn't have those protections. FMLA is unpaid. Yes. Yes. Although I would suggest that if your contract says otherwise, then it's. She asked that question. Let's see. I think that that's one of the things that is still commonly misunderstood is that, you know what, when I talk to younger people, they don't realize that there's no such thing as maternity leave in the United States, and there really isn't. And FMLA comes the closest, but it's only 12 weeks. So some of the cases talk about what happens if you need more than 12 weeks. You know, 12 weeks obviously doesn't cover the entire pregnancy, so what if you have complications beforehand where you have to be on bed rest or something like that, where you're unable to go to work? You're going to expire all of your FMLA work. And still, even then, there's some situations where the big thing is that they don't have to pay for your health care benefits. So when my wife used FMLA for the birth of our daughter, we had to write a check to pay for the health care benefits for the time period she missed work. Otherwise, she would have lost her health care benefits because it's unpaid leave, and therefore you're responsible for 100% of the benefits or whatever, too.
I think the example was the federal maternity leave where a lot of people like that saying it's based on a lot of women
Well, and I mean, definitely, that's one of the things. Originally, it wasn't as crystal clear in there that pregnancy was covered by it, and they broke it off separately, so you don't have to consider it to be a serious injury. Let me talk about what happens, though, as sort of a transition towards the end here. What happens as if you run out of FMLA leave? What happens after you use all 12 weeks of your protected leave? By the way, for service members, for the service members leave, it's actually 26 weeks, not 12 weeks. So the service members, or care for service members, actually get more. But if you run out of that leave, what happens? As soon as you go one day over the 12 weeks, you are no longer protected from discrimination or from interference or from them not putting you back to your job. So they have to return you to the same or equivalent job, and that relates to pay, and job status, and job duties, and things like that. If you go over the 12 weeks, they don't have to do that. They don't have to put you back into that situation. And a lot of times what happens is they're going to, you guys have talked about it a lot, the attendance issue. What they're going to do is after 12 weeks, they're going to start accumulating points or absences, however they do it, and then they're going to terminate you. So if you miss 13 weeks, you're likely to get a letter that says your FMLA ran a week ago, we counted the last week as unexcused absences, you're fired. So you have to keep in mind that FMLA provides them 12 weeks, and that is essentially all that is provided.
Thank you very much.